Welcome to immigrationquestion.com, your go-to resource for U.S. immigration insights. We provide clear immigration news and information. Our platform provides a network of licensed attorneys who can answer your questions and guide you through the process. From visas to green cards, asylums to citizenships, immigrationquestion.com helps you to network with immigration attorneys so that you can move forward with confidence. Sign up today or download the app. Free registration, limited time offer. Stay tuned. We go live in 30 seconds.
Hello everyone and welcome to the special edition webinar hosted by immigrationquestion.com, a networking platform and meeting ground where immigrants, families, advocates and licensed immigration attorneys come together to understand US immigration policies and procedures better. My name is Chibi Situsa and I'll be your host for today's special session, Federal Litigation, When to Sue for Legal Status. Now, delays or prolonged inaction on immigration applications can create uncertainty and frustration for many immigrants. In some situations, applicants may consider turning to federal court to challenge delays or adverse immigration decisions. Now, understanding when litigation may be appropriate, what legal remedies are available, and what risks applicants should consider is important for individuals facing such situations. To help us break this down, we are honored to be joined by John Ting, Esquire, an immigration attorney who handles complex immigration matters, including federal litigation involving USCIS and the Department of State. Attorney Ting, thank you so much for joining us today. We're thrilled to have you for this important discussion.
Thank you for having me here, GB. Thank you so much. I'm happy to answer your questions and make sure people know the information so they're not stuck waiting time after time.
Thank you so much, Attorney. Before we begin, though, a quick reminder to our audience, immigrationquestion.com is a public educational and networking platform. The information shared today is for general informational purposes only and does not constitute individualized legal advice. If you're joining us on Facebook, YouTube, LinkedIn, or any other platform, welcome. Please subscribe and share this session with anyone who may benefit from understanding immigration litigation options. Attorney Ting, let's dive right in. Can you explain what federal litigation means in the immigration context?
Yeah, so most people don't know about this. Litigation is used when for several different reasons. Number one, when there's a delay on the case, and in legal terms, we call it unreasonable delay. So it does take experience to know, first of all, how long cases usually take. Sometimes it's plus or minus a few months, given the system, the way USCIS operates. Then there's other scenario related to immigration where USCIS unfortunately erroneously denies people. Sometimes when we review people's denial notice, it only has a list of legal parameters, the requirements, but it doesn't actually say why this person is not eligible or why they're denied.
All right. Now, what types of immigration cases are most commonly brought into federal court?
The most common, I would say the majority, are when a mandamus lawsuit, when there's an unreasonable delay. And the sad part about this, GB, is that most people don't even know that federal litigation is an option. So that's why thank you for allowing me to be here and share more about this.
It's an honor for us to have you, Attorney. Now, can you tell us how long does a case need to be pending before it becomes reasonable to consider litigation?
Thank you for asking. You know what? It depends on the case type, basically the form number. So some people could be waiting for I-130, which when people are watching this in the recorded version, the timing could change. So as of right now, for example, file I-130 only petition where someone is abroad or they have to eventually go abroad overseas for the interview, the average timing of that, median timing, is about 17 months. That's the expectation. So if it takes more than 20 months, for example, then we would recommend someone to file a lawsuit for that. Or if it's someone have filed their asylum application, I-589, it was on track, a little bit on track before 2016 or before 2017 when President Trump, his first term, but then he changed the policy. His policy was last in, meaning the most recent application filed will be the first one to be heard. So that kind of the people that were next in line in January 20th, 2017, it got flipped around. So unfortunately, the people, so right now it's about at least 4 years if they've been waiting since the receipt date. Then we would suggest to file for a to get their interview.
Yeah.
Okay, interview scheduled. That would be the result.
All right.
And sometimes you might be surprised in general for any application for adjustment of status or waiting for interview for that or waiting for interview for asylum. Some people already had already had the interview, but now they're waiting for a decision. And sometimes that have taken people 6 months to a year. And they're still waiting. So they're looking for-
Now, Attorney Ting, you touched on a writ of mandamus. Can you explain what it is, and when is it appropriate to file a writ of mandamus?
So yes, what I just shared about the timing, that's when you file it, and most people won't know that, right? So I don't think that would be on something that you could Google search. Unfortunately, that does take experience, and I don't know of a lawyer that has put it on their website. That that's a good idea, but timing can change things over time, like from this year to next year. But a writ of mandamus is what is a legal mechanism, the cause of action, basically the legal reason to force the government agency, being USCIS or even the State Department, to move the case along to the next step. So if I may share one misconception is that some people ask that, oh, if I file this lawsuit, will I get approved? Well, I mean, that's the goal, that personal goal, but our goal is to get it to the case to the next step, the USCIS case, for example. So if waiting for interview, then the goal for us is to get that interview scheduled. Or if they already had the interview, then our goal is to help them get the decision. So unfortunately, because we did not help them with the USCIS application, for example, then we have no control over the possibility of that being approved or not. So that's why for us, we do a courtesy check to review to see if anything's missing from their application, or in terms of evidence at least, so that they can be prepared if they should be waiting for like a request for evidence, for example.
All right. Now, when an immigration case is denied, what options are available for challenging that decision in federal court?
Thank you for asking. So we would file, one possibility is to file a lawsuit for an erroneous denial based on a violation of the Administrative Procedures Act. We call it the APA for short, if people are Google searching that, for example. And that's one option through federal litigation. Another example is maybe filing an I-290B, that is an motion to reconsider application with USCIS. Sometimes every situation is different, depends on the facts, what has been already provided to USCIS. So one option is not always the best option for everyone. And the third option is to not do the first two, but to refile the case entirely. So it depends if they provided the appropriate evidence to begin with.
All right. Attorney Ting, what are the risks of filing a lawsuit against USCIS or the State Department of State?
I'm sorry, what was that big first part of that question?
Oh, sorry. What are the risks of filing a lawsuit against the USCIS or even the Department of State?
The risk, okay. So, people ask me, is it a chance that the government could retaliate? And most people think, okay, well, what do you mean by retaliate? And that is most people are concerned, like, oh, is my case going to be result in a denial or visa refusal? And usually, if people had a case where they were not eligible, right? Because most people that we receive referrals from other attorneys who have clients that need this service. So I tell them, look, we didn't prepare a case, so we don't know anything about your case and the inside of it, but we're happy to take a look and talk with your attorney. And usually most cases, people have everything's filed properly, nothing is missing. So there, in our professional opinion, there is very minimal risk. But yes, we want to address the elephant in the room. A person's case could be denied, but it's not because of the lawsuit. It's because maybe they weren't eligible to begin with, or they were missing documentation, or, for example, just one more example, there's so many examples, but one of them could be that their marriage certificate or divorce certificate was not in compliance with the Department of State, even though it looks like it.
All right. Now, looking ahead, attorney, what should applicants keep in mind to balance risks, costs, and potential outcomes when pursuing litigation?
Absolutely. So even when a law firm refers their client to us to file this lawsuit, and this is a mandamus lawsuit, for example, for unreasonable delay, we do a professional courtesy request. Say, can we look at your client's file because we want to just make sure everything's missing. That could be awkward, right? Talking to another law firm saying, "Did you do everything correctly here?" But what we really ask is, in a different way, is there anything we should be concerned about before we file this lawsuit? Because if so, we can't do anything to change that right now, but to be ready if after we file the lawsuit that they should be ready if there's a request for evidence in the future, right? Because let's say we file the lawsuit and then each of them already know that there could be an issue that they need to correct or be ready with certain documentation. I'd rather have them be ready by the time we get it, so that as soon as we get the request for evidence, that they just mail in the next within 1 week, preferably.
Thank you so much for those insights, attorney.
Sure thing.
Now, for everyone watching, this discussion about federal litigation is not meant to encourage unnecessary lawsuits, but to provide clarity about the legal remedies that may be available in situations involving unreasonable delays or disputed immigration decisions. Now, understanding the legal process and seeking proper guidance can help applicants make informed decisions about their cases. If this is your first time joining us, welcome. ImmigrationQuestion.com is a networking platform where users can ask immigration-related questions at no cost and engage with participating attorneys. We're also proud to share that ImmigrationQuestion.com is BBB accredited and ISO certified. So this reflects our commitment to transparency, accountability, community education, and security. Now, Attorney Ting, based on your experience handling immigration litigation matters, how would you say a platform like ImmigrationQuestion.com helps immigrants and immigration attorneys like yourself?
Well, for one, GB, this is a wonderful platform to allow people to really just know what's going on with immigration world, this area of law, because some sources are not credible. And so far, my experience with immigrationquestion.com, because you're inviting guests like myself, we're the real-time practitioners and sharing real-time scenarios. So I think there's a wonderful platform that y'all are doing to share information, resources for people who visit your platform.
Thank you so much, Attorney, for those thoughts. Before we go to our live Q&A session, let's tackle this important question, but you already touched on it. What is another misconception that immigrants may have about suing immigration agencies that you believe should be clarified before embarking on the process?
A misconception is that most people think that maybe when they do an internet search that they read or they heard about, like, oh, this person was successful by just submitting inquiry. And submit inquiry means with USCIS, for example, and the typical response is, okay, they'll get back to that person within 30 to 60 days. And then that's the first misconception. And they usually respond back with, I would have to say 99% of the time, even though I don't have everyone's data point, right? Majority of people tell me on my live show that they just responded with something generic, that the case is still within processing time. So it's very unfortunate. And what's more frustrating for everyone that understands that their case is likely delayed is they check their case status. It seems like every week that people tell me, and it doesn't seem to move the needle, that their cases seem stuck. So, and then the other misconception that's related to that is that if they contact their local politician or elected official, that might do something. What it does do is just waste more time, to be honest. I have maybe heard 1 out of 100 times that it worked to do something. So it doesn't cost people money to do that. You could certainly try it, but you have to have real-time expectations. That is usually what people receive a response from the staffer, from the elected official's office, is that the reason it takes them time, for example, because the staffer sends an email or contacts a USCIS liaison, and then receives back some kind of response, and they forward that response to you or to applicants, and it's either case is still undergoing background check or case is still within processing time. So it's just more of a case update versus case movement. And I think that's the main misconception about submitting inquiry and contacting your elected official.
All right. Thank you so much for that. If you're just joining us, we've been speaking with attorney John Ting on federal litigation, when to sue for legal status. We're now moving into our live Q&A session. This is your opportunity to ask general questions and hear educational insight from a licensed immigration attorney. Please drop those questions in the chat or call us live at 516-703-3483, and we'll take as many as time permits.
GB, can I share an announcement, if I may, in the meantime?
Sure.
Thank you so much. So actually, it just happens that today is the last day that we're asking people to join our group lawsuit. We're aiming for class action certification in federal court, but this is based on people who are a national or citizen of 39 country pause list. So I know a lot of people are frustrated, understandably, that they've done everything correct, filed the application correctly, and they're still waiting. And so even if someone filed last week or yesterday or been waiting 12 months, this is not about mandamus for unreasonable delay. It's just more about what people call lifting the pause to get that cloud off their case, essentially, so the case can resume processing. So if anyone's wanting to ask questions about that, we're welcome to. I'm happy to answer.
All right. Thank you so much, attorney. You heard it, guys. Right. Let's go into those questions. Grace is asking, if I sue immigration, I hope they won't deny my case out of anger or retaliation. Okay.
Thank you, Grace, for the question. So I haven't personally seen that. I know several attorneys that also do what we do, federal litigation as well. And I haven't had, I'm in several different groups and listservs. Knock on wood, I have not heard of anyone contacting and sharing that someone's been denied because they think it was retaliation. So in my humble opinion, I don't believe these USCIS officers have time, the energy to even look at a case and say, look, I don't like this person. I don't like the person's name, so I'm going to deny that person. No. In fact, I don't believe that they even know if they're required to say, hey, if supervisor says, hey, take a look at this case file, this one's next on deck. They're just doing their job. They're just reviewing one case at a time. I don't believe there's any animosity on one case or another.
All right. Abdi is asking, my friend said I can use a mandamus lawsuit to get a faster response to my application. Please, what does that mean?
Yes. Hi, Abdi. Thank you for your question. So, for example, you cannot file a mandamus lawsuit at any time you want if you want a successful result. I mean, you can file it sooner, but you don't want it to result in a motion to dismiss by the government party, which is the U.S. Attorney's Office. So that's why for our team, we have a chart. So for example, certain applications have different timing, triggering timing, event timing. So we know when to recommend to file a lawsuit against USCIS or the State Department. So yes, I mean, faster response, it's kind of faster. I mean, but by then you've already waited maybe 1 year, 2 years. So I wouldn't say fast in the sense that if you just filed your application last month, it's not ready to file a mandamus lawsuit. So I wanted to clarify that. Thank you for the question.
Right. Anjuku is asking, can someone sue if their asylum interview has not been scheduled for 3 years?
Okay, so asylum, 3 years. It may have been that way several years ago to be able to wait only 3 years. I know it already sounds like a long time. I mean, it is a long time. But myself, our law firm, and other law firms, we've come to realize that 4 years seems to be the minimum. I've even heard in some other area of the country, you may have to wait even 5 years. Someone I know has received some pushback. So it just depends. It may change from one U.S. attorney's office to another, but minimum 4 years for asylum.
All right. Is it expensive to sue immigration?
Hi, Miriam. Thank you for your question. Cost and fees are subjective, right? Like, personally, I don't want to buy a new iPhone or Android every 2 or 3 years, but if the device breaks down, we have to pay for it, or your transportation, mode of transportation, like a vehicle. It's a necessary thing to do if your case is taking too long. Because look, the U.S. government agency, the U.S. government in general, they're really not there to benefit you. So you have to fight for your rights. And mandamus, or federal litigation in general, overall, is a legal mechanism that can benefit you so that you can move on in your life and basically turn the next chapter, travel, get a better job, for example, with legal status.
All right. Muhammad is asking, my cousin passed her citizenship exams and was about to go for her naturalization ceremony, only for it to get cancelled suddenly. Can she sue for that?
Absolutely, Mohammed. Thank you. You're so nice to ask about your cousin in that regard. I'm glad to hear she passed her civics test and the other exams. Yes, most people that have had the experience the same situation, there's even some people that passed and went to the oath ceremony and they got pulled out of line. I've never seen this in my 14 years of practice, only this past year, okay, with the Donald Trump administration. Okay, and that's because of the pause. So there's 39 countries on the pause list that people are not moving forward because I think some people are misunderstand that passing the English and civics test means that you've been approved. But in fact, they don't actually provide an approval notice if anyone's already gone through this process. If you notice, the per se approval notice is your oath ceremony notice. So it's not really done at all. So yes, mandamus is an option. But it sounds like your cousin, not knowing which country she's from, her country of nationality or birth could be on that list of 39 countries based on what experience our experience thus far.
All right.
So you want to go ahead, if I can make a plug, you want to go to our website, greencardguys.com, to learn more, or just give us a call to learn more about that group class action lawsuit, because today, May 14th, is our deadline by the end of the day.
Can you repeat that, attorney, so that anyone who didn't get that can jot it down?
Oh, sure. You know what? If I can share my phone number, our office number is 346 456 5151. Today, end of day. I know it's already close to end of day. Today is a deadline to participate in the lawsuit, the group class action. And if also anyone's wondering, well, has it been successful before? Yes, it has, in terms of lifting the pause. There's been several group lawsuits by other law firms as well. And in fact, the one that we have joined is with two other law firms, so 3 total, joining forces to help benefit others waiting and waiting.
All right. Ronti is asking, is a family supposed to file one lawsuit together if everybody's case is delayed?
That's usually our goal. Thank you, Ranti, for your question. That's usually our goal, to file one lawsuit. Of course, because that also saves on the court fee as well, and also save on attorney's fees. But we always aim to try to limit the fees if possible. So that's what we recommend first.
All right. All right, I think that is all we have time for today. Thank you to everyone who joined us for this special edition webinar, and thank you, Attorney Ting, for joining us and sharing your knowledge and practical guidance with us today.
Happy to be here. It's my pleasure.
Everyone else watching, you can always visit immigrationquestion.com to ask immigration-related questions, stay informed about policy updates, and register for upcoming live sessions. If you missed any part of today's important discussion with Attorney Ting, the replay will be available on Spotify soon. Just search Borderless Talk by immigrationquestion.com. Attorney said that today is the cutoff date to participate. And what is that website again, Attorney?
You're welcome to go to greencardguys.com and then click, I believe, announcement section, and you'll find that article.
Thank you so much. We look forward to seeing you on Friday at our next live session. Until then, stay informed, stay prepared, and stay connected. Bye-bye.